This is Mike Franklin, the property tax guy, and today we're going to talk about the courtroom television network versus the state of New York. That was some case law that was provided to me by the hearing officer for the small claims assessment review case in the Broome County Courthouse for assessment matter in the town of Vestal. I'm at a loss as to why it wasn't provided to me before the hearing, because it's kind of too late. Once it's at the hearing, people aren't going to sit there and wait while I read this extensive decision. And it should have been provided before, so I could have some form of response. And if you may recall, initially the administrative judge denied me, claiming I wasn't a bona fide member of the press, he said. As this case will demonstrate, that the press has no more right than the public, and so it's really not even relevant whether or not I'm a legitimate member of the press or not. So it's kind of a concerning, that the administrative judge wasn't familiar with that. So then he tried to deny me based on Section 735 of the New York State Real Property Tax Law, saying that it says that there would be to be no transcripts, that the assessment cases are decided on determination, not precedent, and therefore there is no need for a transcript. And it states that there is to be no transcript. And so I need to help the judge with his word roots. So it's transcript, script as in scribe, scribe as in writing. A video is not in writing. And it's really the intent of that section is that the cases are decided based on determination. And so, he's trying to use a vagueness to suit his own agenda, because he basically just doesn't want me to record. And it's what we would refer to in the real estate business as self-dealing. He doesn't want it recorded because he wants to minimize the amount of work that he has to do for his $220,000 plus pension and benefits. And I don't know. I guess he doesn't want to have his hearing officers embarrassed. He doesn't want the public to see how these things are conducted for some reason. And so then he cited Section 131.1c, saying that there are to be no recordings of witness testimony and so on and so forth. And really, Section 131.1a says it's their policy to be open and transparent to the to uphold the confidence that the public has in the judiciary. And denying me recording this hearing really undermines the credibility of the court. And right now I don't have much confidence. But 131D says that the intent of these rules are not to undermine any pre-existing rights, such as the First Amendment. Now, this case is going to say that there is no First Amendment right to record hearings. And they're going to suggest that that's a function of the legislature to allow that. And that's what they're saying. They're saying it's so because they said so. For centuries, people have been allowed to attend these hearings. There can be some limitations if there's rape victims, children, so on and so forth. But I think that's the issue. Even the Supreme Court and the state Supreme Court, or the state Constitution, is saying that is not a constitutional right to record. You have a constitutional right to attend hearings with some limitations, but you don't have the constitutional right to record them. And that's what the Supreme Court has decided. But it kind of reminds me of Plessy versus Ferguson, which it's separate but equal is still equal, because they said so. And that's what this is. You can't record because they said so. And they're right. There was the First Amendment when it was written. They didn't have video recorders. you know. And so since it isn't explicit that you can, in the First Amendment, video record, they're saying that you can't. And of course, why would they say that? Well, because if we could record all these hearings, it would have an impact on the power of the judiciary, and they don't want that. That's kind of what this is all about. It's about power, and it doesn't have anything to do with what's right. But let's review this. So David Boies for the appellant. He's a pretty famous attorney, but he lost this one. Let's see. The primary issue on this appeal is whether Civil Rights Law Section 52, which bans audio-visual coverage of most courtroom proceedings, violates federal or state constitution. And so their ruling is that it doesn't. And but I think that the point is that this case is about recording, criminal trials and so on and so forth. And there are concerns as to whether or not that could impact whether or not they can get a fair trial. But if a defendant in a criminal case, in my opinion, if he wants it recorded, it should be recorded. If there's some victims to protect, of course, you have to protect their rights too. So I believe that there is a constitutional right to record these with limitations that are reasonable and can be articulated. And again, this case is about recording criminal trials. What we're talking about is an assessment pattern, and I'll give you the details of who they want to limit in a little bit. But the bottom line is that the assessor doesn't have any expectation of privacy, nor does the hearing officer. There's nobody to protect, and so I'll get into some more details. Okay. Let's see. So they're granting the summary judgment in favor, against the appellant, because they're saying that they don't have a constitutional right to record. The record is consistent with the traditional approach of New York courts to public access questions, giving great weight to fair trial concerns. See, that's what this is about. It's about fair trial concerns. But there's the taxpayer wants it recorded, so you don't have to protect them. The record is consistent with New York's statutory scheme, which guarantees public trials but gives primacy to fair trial rights, and that's perfectly reasonable if they can articulate it instead of just saying it so because they said so. Moreover, to the extent any changes to the statutory scheme have been put into experimental use, these were initiated and reviewed by the legislature, and ultimately they did some trial situations to see if it would work, and of course they decided that it didn't work. But they don't explain why, of course. Court TV asserts that Section 52 denies it the right of access to trials guaranteed by the First Amendment to the United States Constitution and Article I, Section 8 of the New York State Constitution. Court TV argues further that most states permit televised trials, that New York stands alone in having an absolute ban on televised trials, and that the evidence supporting access to information for the general public far outweighs the attendant problems of having cameras in the courtroom. The New York State counters that there is no First Amendment right to televised trials, because they said so, and that it wasn't specifically written because they didn't have video cameras in those days. And that the concerns of Court TV are more appropriately directed to the legislature than the courts. And so they want the state legislature to decide whether or not, you can record the government. That is self-dealing as well. The state additionally argues that allowing cameras in the courtroom is a discretionary policy determination that may be made by the legislature. Um, the legislature cannot anticipate every eventuality. Um, you know, so they're saying it is so, but they're just not backing it up. The let's see here. First Amendment. The First Amendment to the United States Constitution guarantees the press and the public a right to access to trial proceedings. Without the right to attend trials, which people have exercised for centuries, important aspects of freedom of speech and the press could be eviscerated, which is kind of what we're doing here. In other words, what they're saying is that people can attend these things in person, but they can't record to disseminate it to the rest of the country. They want to force everybody to go to every trial. It's just not practical. It's ridiculous. Though the public acquires information about trials chiefly through the press and electronic media, the press is not imbued with any special right of access. Rather, the media possesses the same right of access as the public. And of course, the Judge Faughnan said that I wasn't a legitimate member of the press. This kind of demonstrates that it isn't even relevant whether or not I'm a legitimate member of the press or not. But seeing as I do disseminate assessment information to the public on a regular basis, there's no doubt that I am legitimate press, but it just doesn't matter. So that they may report what people in attendance have seen and heard. Thus, the press has no right to information about a trial superior to that of the general public. Okay, so that takes care of that issue. It's not relevant whether I'm legitimate press or not. It's a public hearing in a public space, and I have a right to it. Unless they can articulate a reason why it would interfere with somebody else's rights. Civil Rights Law 52 does not prevent the press, including televised journalists, from attending trials and reporting on the proceedings. What they cannot do under the statute is bring cameras into the courtroom. This is not a restriction on the openness of court proceedings, but rather on what means can be used in order to gather news. It's just outrageous. They're protecting themselves. It's self-dealing. They don't want to be accountable. They don't want to be transparent. They want to do whatever it is they please. The media's access is thus guaranteed, but it does not extend to a right to televise those proceedings. There is a long leap between a public right under the First Amendment to attend trials and a public right under the First Amendment to see a given trial televised. And I disagree. It is not a leap. You should be allowed to do it unless there's a reason why you would interfere with somebody else's rights. It's just outrageous. Estes versus Texas is the seminal case on televising a trial. 5 justices concurred in the court's holding that the defendant had been denied due process because of the televising and broadcasting of his trial, and held there was no constitutional right to the press to have access to the courtroom during the trial. Well, here's another example. They're interfering with somebody else's rights, and if that person has rights, and if he doesn't want to record it, it shouldn't be recorded. In other words, there's an application, a video application that you submit to the court before the hearing, and the judge has to weigh if you're interfering with anybody's rights. And in the assessment case, I absolutely am not, because the assessor has no expectation of privacy, neither does the hearing officer. There is no victims to protect. So again, that's what this case is about. It's about protecting victims and defendants, but there are none to protect when it comes to assessment matters. So yeah, there is a constitutional right, but like any right, there can be time, place, and manner restrictions, and that's what those are. But there are none in the assessment hearing. The court listed a number of concerns about the presence of camera at the trial, including the prejudicial impact of pretrial publicity on the jurors. That's an example where the court would have some discretion to deny it, but they need to articulate a reasonable reason for doing so. They can't just say it's so because they said so, and that's what it is that they did in my hearing case. It's ridiculous. The impact on the truthfulness of the witnesses, responsibilities placed on the trial judge to assure a fair trial, and the impact on the defendant. Well, the fact that these people are covering up these hearings, it means I can't get a fair trial because they're just going to brush it under the rug. Allowing it to be recorded would assure me of a fair trial. The court wrote, a defendant on trial for a specific crime is entitled to his day in court, not in a stadium or a city or nationwide arena. Again, it's so because he said so. If that defendant wants the thing recorded, it should be allowed to be recorded. If there are victims that need to be protected, then you have to protect those victims. But in general, it should be open. Just putting people in jail for life, without anybody being able to know what transpired is not appropriate. The court did acknowledge that the ever-advancing techniques of public communication and the adjustment of the public to its presence may bring about a change in the effect of telecasting upon the fairness of criminal trials. Today, television has become a commonplace affair in the daily life of the average person. While the Supreme Court has revisited the effects of televised coverage of trials, concluding that such broadcasts are not a per se violation of fair trial rights, it has never deviated from its holding that there is no constitutional right to have live witness testimony recorded and broadcast. Thus, it is clear that the federal Constitution does not require courtrooms to be open to the televised court proceedings. By default, they should be open unless there is a reason that they should not. Time, place, and manner restrictions. The New York State Constitution similarly does not provide a right to televised trials. And they go on to say that there's no Civil Rights 52 is not unconstitutional, and they're claiming that it's not violating the freedom of the press. And in New York, the press, like the public, has a right to access criminal proceedings. This includes access to pretrial hearings. We conclude, therefore, that the public and any press may have a First Amendment right of access to pretrial suppression hearings. Any exception to a public trial should be narrowly construed. While we reaffirm today that the inherent discretionary power of the trial court to close the courtroom, we need only point out that the discretion be sparingly exercised, and then only when unusual circumstances necessitate it. You need to articulate it. Court TV relies on courtroom closure cases to suggest that New York has granted the press broader rights than those provided under the First Amendment. But even if the right to access was the equivalent of a right to televised courtroom proceedings, which is not, our cases do not support appellants' assertions. Even prior to Estes, New York did not recognize any independent right of the press beyond that of the public to have access to the court. The court held that the press had no independent right to request that the courtroom remain open, separate from the defendant's right to make either a request for the court or to remain open or closed. In fact, our approach to courtroom closure has been comparable to the federal analysis. In imposing such a restraint on the press, the government must show that there is a legitimate governmental interest which outweighs any constitutional right of access by the press and the public. In imposing such a restraint on the press, the government must show that there is a legitimate governmental interest which outweighs any constitutional right by the press and the public. Of course, they're saying it's not constitutional, which is ridiculous. They need to demonstrate that there is a legitimate governmental interest to deny my right to record these assessment hearings. It's ridiculous. Government has the burden of proof of proving that the governmental interest outweighs the constitutional right. The primary governmental interest, both state and federal, is guaranteeing that the defendant receives a fair trial. Again, in the assessment hearings, there's no one to protect. Consistent with that interest, the court must be concerned with the defendant, jurors, witnesses, attorneys, and the public at large. It doesn't say anything about assessors, and it doesn't say anything about the judge or the hearing officer. In Westchester, The court stated, all court proceedings are presumptively open to the public, but when this would jeopardize the right of the accused to be a fair trial, the competing interests must be balanced and reconciled as far as possible, which is perfectly reasonable. But that's not what the Eugene Faughnan, the administrative judge, is doing with these assessment cases. The governmental interest of the right of the defendant to have a fair trial and for the trial court to maintain the integrity of the court outweigh any absolute First Amendment or Article I, Section 8 right to the press or the public to have access to trials. The court has clearly and unequivocally held that the state constitutional right of the press to attend a trial is the same as that of any citizen. So it doesn't make any difference if I'm a legitimate press or not, even though I am. The fact that petitioners are in the business of disseminating news gives them no special right or privilege not possessed by other members of the public. Since the only rights they assert are those supposedly given every citizen to attend court sessions, they are in no position to claim any right or privilege not common to every other citizen. I don't have a problem with that. Okay. And it's getting to the point of ad nauseum. But Eugene Faughnan disagrees. He doesn't see it that way. In Johnson Newspaper versus Millino, 1990, this court held that there is no broader protection for the press under the Constitution, so on and so forth. So that's more ad nauseum. Okay. And then the state had some trial years, where they allowed it, and then they reviewed it and decided they didn't want to do it anymore. So the ban continues as of 1997. Yes, the legislature has not seen fit since 1997 to amend Section 52 or reenact Section 218. Go figure. The legislature does not want to be transparent and accountable. We will not circumscribe the authority constitutionally delegated to the legislature to determine whether audiovisual coverage of courtroom proceedings is the best interest of the citizens of this state. And, of course, they're not concerned about the best interest of the citizens of the state. They're most interested in maintaining their power. A state constitutional rule expanding the rights of the media in New York to include the right to photograph and broadcast court proceedings would derail what is and always has been a legislative process. So they're suggesting the legislature should be doling out constitutional rights, is what they're suggesting. It's just crazy. So anyway, the order is affirmed with costs, and so on and so forth, by Judge G.B. Smith, Judge K. and Judges Siparik, Rosenblatt, Grafeo, Reed, R.S. Smith concur. Jesus Christ. Footnotes. No person, firm, association, or corporation shall televise, broadcast, take motion pictures, or arrange for the televising, broadcasting, or taking of motion pictures within this state of proceedings in which the testimony of witnesses by subpoena or other compulsory process is or may be taken, conducted by a court, commission, committee, administrative agency, or other tribunal in this state. Well, there is no witness testimony. It's just the assessor, and it's just the hearing officer. So it just doesn't apply. Number two, since there is no pending action by the district attorney of Manhattan, it's dismissed. We note that after Chandler, no federal circuit court has opined that the federal Constitution guarantees the media a right to televise trials. Okay. First Amendment. Okay. Let's see. More of the same. More of the same. So they're saying there's no constitutional right to video record hearings, although you can attend them. That's what I think. What we have is a panel of Luddites, is what we have here. They think that you have to write in the Constitution that you can't video record, even though they didn't have video recorders back then. That's crazy. Um, Sittings of courts to be public. The sittings of every court within the state shall be public, and every citizen may freely attend the same, except that in all proceedings and trials, in cases for divorce, seduction, abortion, rape, assault with intent to commit rape, criminal sexual act, dastardly affiliation, the court may, in its discretion, exclude therefrom all persons who are not directly interested therein, excepting jurors, witnesses, and officers of the court. Again, this doesn't pertain to assessment matters. Okay, there's nobody to protect. Because we conclude that the Civil Rights Law 52 does not affect a federal or state constitutional right, we need not consider Court TV's argument that the state's law should be analyzed under a strict scrutiny standard. Even if we were to consider Section 52 under a constitutional lens, however, it would pass constitutional muster. This court concludes that the because they said so. This court concludes that the statute is narrowly tailored to serve the governmental interests at issue. Yeah, namely, ensuring that criminal defendants receive fair trials. That's what 52 is about. It's a civil rights law protecting criminal defendants. It's not to protect assessors and hearing officers. And that the trial court has control of the courtroom and that the integrity of the trial is maintained. Well, that's the maintaining decorum is the job of the hearing officer, but it doesn't mean that they can restrict free speech. When Judicial 218 was in effect, the court system itself exercised control over the means of access to proceedings made available to broadcast media under the rules of the chief administrator of the courts. These are just laws made up to avoid the government being accountable to the people, and that's the that's the entire case. So I may have ad nauseumed it, but that's the bottom line is that they're saying that there is no First Amendment right to record, and I disagree. But that right would have limitations, and the limitations have to be articulated and they have to be reasonable, to protect people having a right to a fair trial and to protect victims and so on and so forth. There's no problem with that, but it doesn't mean that they can use it to protect assessors and to protect themselves. That's not what it's about. But they're saying that the legislature should make these determinations, so they have to fix Civil Rights Law 52 to be more specific about what it is that they're doing. Although it seems pretty specific to me, but it's sufficiently vague that it gives these judges the ability to see it however they want to see it. That's kind of the problem. So again, the judge says I wasn't a legitimate member of the press. It's not relevant. He said that per 735, we can't record. We can't create a transcript. A video recording is not a transcript. Transcript is a script. It's in writing. It's got nothing to do with video recording. The section 131.1 A supports my position. 131.1D supports my position, and section 131.1 C is just New York State is the only state that does an absolute denial. It's just outrageous. So I think 131.1 actually supports my position, and then they cited 131.3, which is a checklist of when you provide your application to video record the hearing. They have a checklist of things for the hearing officer to do, and number one item is to interview the applicant, which they never did. So if they didn't do number one, well, they probably didn't do the rest of them either. So the bottom line is the Administrative Judge Eugene Faughnan simply doesn't want these hearings to be recorded because it might cost him some work, and it might not, it might expose what goes on in these hearings, and show the public that there's issues with the SCAR law. So So anyway, I think it's pretty outrageous that they didn't provide me this case law before the hearing, so that I could respond to that. So I could have recorded the hearing. I don't. They have not articulated a reasonable explanation as to why it would be inappropriate for me to record these hearings. Who is it that they are protecting? And I'm going to suggest that it's self-dealing. They're protecting themselves, is what they're doing, and they're trying to minimize the amount of work that they're doing. He's getting paid $220,000 a year to do this job, and he's protecting his own interest, not that of the public. These SCAR laws not being recorded is detrimental to property owners, and property owners are the foundation of this country. Property owners don't burn police precincts. They don't burn police cars. They don't burn car dealerships. They're the foundation of the country, and they need to be protected. And this administrative judge denying these matters, there's nothing more public than assessment matters. And that hearing and that administrative judge denying this matter being public is highly, highly detrimental, and it's just plain wrong. This is Mike Franklin, the property tax guy.